Assalamualaikum and hi, my name is Nur Patricia binti Kamaruddin and I'm from section 301, and today me and my friend will present about consideration can be a promise not to sue. It's actually one of the rules of consideration, and before we go straight to the main point of what is consideration can be a promise not to sue, I will explain briefly about what is consideration.
Consideration is usually described as paying something which represents either a benefit to the person making the promise, the promiser, or a detriment to the person to whom the promise is made, the promisee, or both.
So, what do you guys learn? We can clearly see that each party are obliged to give something valuable or an act in return for what they had gained from the other party. It's actually the matter of fairness. And consideration is actually one of the essential elements of a valid contract, because without the consideration, you can't enforce the contract or the agreement in the court. The concept of consideration can be a promise not to sue is in the situation where the party has a possible civic claim against the other party, but the promise not to enforce that claim is actually a good consideration for a promise given in return.
For example, in this situation where Party A causes harm to Party B, Party B might agree that they will not sue Party A if Party A pays for the damages, and Party B's promise not to sue will be the consideration for Party A's promise to pay.
I have a deal. I won't sue you, but you have to pay me for the damages that you have done.
Fine, I'll pay for the damages.
This concept is often used in settlement agreements and releases, where one party agrees not to pursue legal action in exchange for some form of consideration from the other party.
I want to share with you guys about a case related to one party's promise not to enforce an existence can only provide consideration if the promise given in return was actually induced by the promise not to enforce the claim, which is the case of Combe versus Combe 1951. So in this case, Mr. Combe and Mrs. Combe are spouses. During their divorce process, the husband promised to pay to his wife a tax-free sum of £100 each year to represent a permanent maintenance. However, the wife was aware that the husband was not in a good financial state and she made no claim to this payment. But the husband failed to fulfill his promise of financial support. Dissatisfied with this situation, the wife took a legal action claiming that the husband's promise was binding and she was entitled to the support he had pledged. So the case proceeded to the court with a crucial intention on a legality of Mr. Combe's promise. The wife claimed the existence of a valid contract based on this promise and request enforcement, contending that she provided consideration by refraining from applying for a maintenance order. But in contrast, the husband argued that there was no consideration and making the promise unenforceable. It was held that this could not be consideration because her husband had not asked her not to apply to the court. Therefore, his promise had not been made in return for her promise not to do so. The wife could only enforce the agreement for the payment which was promised by the husband if she had given consideration. But the court found that there was no consideration was given by the wife as she had not agreed to apply for the maintenance that was promised by the husband. And also, the husband did not request from the wife to refrain from taking the maintenance payment, and therefore, the wife could not claim for the money.
Meanwhile,
hello everyone, so today we're going to see the interpretation of the consideration rules promising not to sue in a leading case, Alliance Bank and Group. So, in this case, the plaintiff is the Alliance Bank and the defendant is Mr. Broom. So, the story begins when Mr. Broom owed the bank an unsecured loan. Then, the bank asked for some security which the defendant agreed to provide. And one day, the bank proceeded to enforce the debt with Mr. Broom because Mr. Broom promised to provide some security for the plaintiffs, but he never produced them. And then, when the plaintiffs bring this issue to the court and try to enforce the agreement for security, the defendant argued that the plaintiffs had not provided any consideration for his promise to provide security. So, what do you guys think the legal issue that need to be determined by the court for this case? So, the legal issue here is, could promising not to sue Mr. Broom constitute good consideration for his promise to provide security for his debt? The answer is yes, the claim is allowed. It was held normally in such a case where the bank would promise not to enforce the debt, but this was not done here in this case. For the conclusion, by not suing, the bank actually had shown forbearance, and this was a valid consideration. Therefore, the agreement to provide security was legally binding.
Meanwhile,
So the relevance of these rules is that it allows parties to settle their disputes without going to court, which can save their times, money, and energy. By promising not to sue, they can avoid litigation and reach an agreement. This promotes trust between them and help to reduce the burden on the legal system. However, the promise needs to be made in good faith, supported with some benefits, clear and certain, and also not contrary to public policy or law. Otherwise, it may not be enforceable. This principle is based on the idea that the promise not to sue is a surrender of the right to claim legal pursuit, which is a sufficient detriment to the promisee and a benefit to the promisor. So these rules of consideration can be related with the two decided cases mentioned. The first one is in Alliance Bank and Brooms, where the court held that the promise to provide security was supported by the consideration of forbearance, meaning that the creditor did not sue the debtor for the debt. This was implied from the debtor's request for security and the creditor's agreement to wait. Therefore, here the promise not to sue was a valid contract and is enforceable in the court. Then in the second case, in the case of Mr. Combs and Mrs. Combs, the court held that the promise to pay the maintenance to the ex-wife was not supported by any consideration because the wife did not suffer any detriment or provide any benefit in exchange of the promise. And the promise was not made upon the request of the ex-husband, nor was it legally enforceable. Therefore, here, the promise was not enforceable in the court and didn't form valid contract. So these cases shows that the promise must be made upon the request of the promisor, and the promisee need to give up a legal right or assume a legal obligation in exchange for the promise. Another condition is that it must be clear and certain and not contrary to the public policy or law. If these conditions are met, then the promise can be a valid consideration for a contract to be made.